I would finally just note that if you just look at the text of the First Amendment, it doesn't say merely that it protects religion or religious status. It says it protects the free exercise of religion. And to exercise your religion, at least in most cases, you have to not only have some sort of religious status, but also use your time, effort, and resources to practice your religion.
Hello, everybody. I'm Max Nospish, Manager of Visitor Experiences here at the First Amendment Museum, located in Augusta, Maine, where we help people understand and inspire them to live and love their First Amendment freedoms. Thanks for tuning in to this one-on-one interview. Today, I'm joined by Ilya Somin, who is a professor of law at George Mason University. Thank you for joining us.
Thank you for having me.
Why do you think the First Amendment is important? What are its goals and purposes?
The First Amendment has multiple different goals and purposes, but basically it protects people's right to freedom of speech. It also protects other related freedoms, such as freedom of assembly and the like. And most relevant for our purposes today, it protects the free exercise of religion while also protecting against the establishment of religion by the government. And I think as with freedom of speech, that is both because freedom of religion is intrinsically valuable, but also because if the government starts undermining freedom of religion, it could have harmful societal consequences of various kinds.
The reason why we asked you to participate and why we're interested in talking to you is you recently wrote an article entitled, "Why the Supreme Court Got It Right in the Main Voucher Case." Could you tell us, for those who may not know, what is the Main Voucher Case and what is this article and why did you write it?
So this case arose out of a relatively small program in the state of Maine, which is a lot of remote communities that are thinly populated. And some of them are so thinly populated that they can't support their own public schools. So in places like that, the state of Maine has a voucher program, which gives people who live in those areas, if they have school-age children, it will subsidize their attendance at private schools, or in some cases also in other public school districts. And while the program, as structured before this case, did not categorically exclude all religiously affiliated schools, it did exclude what they called sectarian schools, which they essentially defined as any schools in any way promote religion or their religious identity and the like in their curriculum. And plaintiffs or parents in Maine who wanted to use the voucher program to send their kids to religious schools, they filed a case arguing that this is discrimination on the basis of religion and therefore a violation of the free exercise clause of the First Amendment.
So what is the crux of your argument in your article you wrote? How do you think the Supreme Court got it right in this case?
So even before this case, the Supreme Court had previously ruled in the Espinoza case in 2020 that it is impermissible in a violation of the First Amendment for the government to discriminate against religious schools in a voucher program simply because they're religious. So the defenders of the program in this case, and also the dissenting justice in the Supreme Court, they said this is different because we're not discriminating on the basis of religion as such. We're discriminating on the basis of the religious use of the money. So if a private school that is quote unquote sectarian gets the money, it might use it for religious purposes. And that's discriminating not based on the fact that they are religious, but that they might use it for religious purposes. And the Supreme Court majority, I think for very good reason, rejected this so-called religious status versus religious use distinction because ultimately it's kind of nonsensical and breaks down. First of all, almost any private school which is religious in more than just name is going to promote its religion at least to some degree. And second, in virtually every other context, is pretty obvious that discrimination based on this use distinction would be unconstitutional. I would finally just note that if you just look at the text of the First Amendment, it doesn't say merely that it protects religion or religious status. It says it protects the free exercise of religion. And to exercise your religion, at least in most cases, you have to not only have some sort of religious status, but also use your time, effort, and resources to practice your religion. So I think for that reason, the Supreme Court got this right, because ultimately there's no real distinction between discriminating based on religion and discriminating based on so-called religious views.
What are some of the arguments of people who say, no, respectfully, we disagree. What we think the Supreme Court got it wrong. What is their perspective as far as you understand it?
So there's a whole bunch of different arguments, but some people say that if the government gives money to religious institutions, then that violates the Establishment Clause. That is, in effect, means that the government is supporting or establishing this religion. And I think that would be true if the government says, here's a pot of money which we're specifically allocating for religious purposes. Like we want to specifically promote the Catholic Church or the Mormon Church or a synagogue or something, or even if we want to promote religious institutions, but not give similar benefits to comparable secular ones. But mere non-discrimination in the provision of a generally publicly available service to everybody, that I think is not the establishment of religion. If it was, then it would be the establishment of religion every time we give welfare benefits for food stamps, say, to religious people who then use them in religious ways, say to buy kosher food in the case of an Orthodox Jew. Similarly, if the fire department protects a church against being burned down, or a police department protects it against being broken into, then you could say that's the establishment of religion, because they're protecting an institution and the protection then facilitates that religious institution's religious activities and so forth. So I think non-discrimination is not establishment.
So how do you use the First Amendment in your own life, whether it's personally or professionally?
So writing articles is, in fact, one way that people can use their First Amendment rights. Obviously, it protects us when we criticize the government. As an atheist, I also make use of the principle of non-discrimination on the basis of religion that I mentioned earlier, in that obviously atheists are one of the least popular religious minorities in the US. And so we, in a discriminatory regime, we may be more likely to be discriminated against than most other groups would be.
All right. Do you have any way, anything you want to promote, anything you want to get out to anybody who may be watching this?
It's dangerous to let professors engage in self-promotion because they'll never stop. But let me just mention a couple things. I have a longer piece in the Deseret News, which is available for free online, which goes into some of the issues in this case in more detail. I write regularly for the Volokh Conspiracy blog, VOLOKH, at the Reason website, where we write about a variety of legal and policy issues. And somewhat relevant to this case, I have a book called Free to Move, Foot Voting, Migration, and Political Freedom.
Great. Professor Somin, thank you so much for joining us.
Thank you so much for having me.